Welcome back. In our journey through the financial power of attorney, we have looked at who holds the keys and when they can use them. Today, we are talking about an important aspect, which is, not all powers carry the same level of risk. Some permissions are more sensitive than others, and this lesson is about understanding those higher risk areas and learning how people commonly add safeguards. The first and perhaps most significant high-risk area is gifting authority. Gifting means allowing your agent to give away your money or property to someone else while you're alive. This could include cash gifts, charitable donations, or transferring assets. There are legitimate reasons people allow this. Sometimes it's part of tax planning. Sometimes it's part of long-term care or benefit planning, such as part of a Medicaid planning strategy to help you qualify for assistance while preserving some legacy for your family. Sometimes it's about continuing patterns of support, like helping a charity, a child or grandchild in the same way you have in the past. But gifting authority is also one of the most commonly misused powers. If an agent has unlimited gifting authority, they could potentially transfer your savings to themselves or their own children under the guise of planning. The key is to distinguish between strategic moves and what we call looting, the unauthorized draining of an estate for an agent's personal gain. So here's a few options. You can place limits. You can limit gifts by amount. You can limit gifts by who can receive them. You can limit gifts by purpose. You can require that it be consistent with your past behavior so it benefits specific people or causes you've already supported. Placing limits on a power can turn a risky power into a more controlled one. Another high-risk power involves your beneficiary designations. In many states, an agent cannot change who inherits your property unless you explicitly give them that permission in the document. This is a massive safeguard because it prevents an agent from essentially rewriting your estate plan by changing the names on your life insurance or retirement accounts. To prevent this, you can specify that only certain changes could be made or limit your agent's ability to change anything that would impact them. Then there's the concept of self-dealing. This occurs when an agent enters into a transaction that benefits them personally rather than focusing solely on your best interests. The law generally views any transaction where the agent benefits as inherently suspect and potentially voidable by a court. For instance, if your agent sells your car to themselves for $1, that is a major red flag. To prevent this, you could explicitly state whether your agent is allowed to make personal use of your assets, or if they are strictly forbidden from any transaction where they have a conflict of interest or where it may be considered self-dealing. Related to this is the question of compensation. Your agent is often a family member who may serve for free, but they are generally entitled to reasonable payment for their time unless you state otherwise. You may also provide for reimbursement, ensuring they are paid back for any out-of-pocket costs they incur while managing your affairs, such as travel, accounting fees, or property repairs. So, how do we make these high-risk powers safe? You can use an audit trail. A fiduciary has a duty to keep complete and accurate records of every single penny that moves. One of the biggest warning signs of trouble is commingling. This is when an agent mixes your money with their own in the same bank account. Your money should always stay in its own bucket, and your agent should be able to show a receipt for every drop that leaves that bucket. This is where we introduce safeguard tools. Safeguards are not a sign of a lack of trust. They are a sign of professional management. By installing oversight, you are actually protecting your agent as much as yourself. You are giving them a clear set of rules so that no one can ever look back and unfairly accuse them of doing something wrong. Here are common safeguards people choose. Some require periodic accounting to a third party, like a trusted family member or advisor. This adds visibility. Some limit gifts to certain people or amounts. Some require 2 people to approve certain actions, where that's allowed. This can slow things down slightly, but it can also reduce risk. Some require a bond, which is a form of financial protection if misuse occurs. Some name a monitor or protector. This person doesn't manage money, but they keep an eye on things and can raise concerns and have powers to act if something feels off. Each safeguard adds protection, but also adds complexity. In all of this, the goal is balance and determining how to accomplish your goals. By watching this video, you have already moved into the top tier of planners. You now know which powers carry the most weight and how to identify the landmines of financial management. In the next lesson, we'll begin wrapping up this unit by talking about execution, storage, and keeping your plan usable over time.